There's another exhibit, it's a composite exhibit that I'll ask Mr. Connor to speak with briefly as well, that contain some photographs that were found on the phone.
Might be marked as defense composite double Q.
Is on the other copy, please?
I do.
May I inquire?
This is double Q.
No, that one.
Isn't that the one she
Double Q.
I'm sorry, it is, yes, that's double Q. Good evening.
Good evening.
Please state your name for the record and spell your last name.
Richard Donald Connor, Jr., C-O-N-N-O-R.
Sorry, Judge. Thank you. Mr. Connor, prior to you taking the stand, we marked a copy of your CV, and it's been admitted into evidence. Is that correct, Your Honor?
It has not.
Would I so move?
Well, this is a proffer, so if Mr. Connor were going to be testifying in front of the jury, you can move it in at that time.
In order to save time, I would like it admitted into evidence so the court can review it and consider it part of his testimony
Well,
today.
unless there's an objection from the state, I'll review it as a composite, but because when something is marked as evidence, it goes back to the jury. The court hasn't made a determination yet as to whether or not Mr. Connor is going to testify, so I don't want that as an exhibit going back to the jury.
I didn't mean to suggest that it would be admitted into evidence for the jury. It would be admitted into evidence for this proffer for
Well,
this hearing.
then it wouldn't be marked as double N. It would be marked as one for this hearing. So do you have another copy, or do you want me to take that double N?
I have another copy. I was suggesting perhaps that since the jury doesn't get things that are only marked for identification, if the court marked it as defendant's proffer 1, then we would
Well, I'll
keep
have
it
to
straight.
remark that one unless you have another one that you would like to provide. Either way, doesn't matter.
I can retrieve that one, so I have one, and substitute another.
Well, the clerk can just mark that as Defense Exhibit 1 for this proffer. I just wanted to know if that's what you wanted to do.
For that one, sure. Yes.
Okay, thank you.
So, Mr. Connor, does your CV that's now in evidence for this proffer as defendant's 1 generally describe your background and training in the area of computer forensics?
Yes.
In addition to the training specifically as a computer examiner and in forensic computer analysis, are you also a licensed attorney in the state of Florida?
Yes, I'm a member of the Florida Bar.
Have you testified as an expert in the area of computer forensics to include extraction and analysis of information from cell phones in the past?
Yes.
Are some of those instances set out in your CV?
Yes.
Are you certified by Cellbrite?
Yes, I went to their training. At the end of the training was certified in the logical and physical.
Are you generally familiar with whatever their most recent software program is for cell phone analysis?
Yes.
And do you have a licensed copy of the current version that's available to the private sector?
Yes.
And did you use that software in whole or in part to analyze the phone that was represented to be Trayvon Martin's?
Yes.
At some point in the discovery process in this case, did you receive what's been known as a bin file?
There were several bin files, yes.
Was there a bin file that you received sometime in perhaps late February or early March that was represented to be, in effect, the data dump from the flash memory of Trayvon Martin's phone?
Yes, I believe it was February 23rd.
And did you have an opportunity to use your Cellbrite software and other software that may be available to you to begin the process of analyzing the data on Mr. Martin's phone?
Yes.
Were you able to identify text messages, Facebook posts, and such that had been deleted or otherwise hidden from a cursory examination of the phone?
Yes.
Would you describe generally what your process was insofar as the use of the Cellbrite technology?
Well, when you load the data into the Cellbrite physical analyzer software, it runs a series of scripts basically and analyzes and then parses out the data. For example, the names in the contact list, the calls in the phone call log, text messages, emails, the pictures, videos, songs and music, things of that nature. It parses them out. I think it's called the analyzed data section of the report.
Okay. Did you, when you began this process, did you have an opportunity to look at the report, the printout, if you will, that FDLE had done in connection with this phone?
Yes.
And when you did your own analysis, did it indicate to you there may be additional information on the phone that had not been provided in report form by the State Attorney's Office?
Yes.
And what did you do then with the bin file, if you will, and your other resources to try to capture or identify what information that was missing from the State Attorney's report? Well,
the report is only a report of what the Cellbrite reads and interprets and parses. The bin files is more like the physical image of the phone's data, so it contains all the data, all the files, all the free space and everything. So when I have the bin files and I've loaded it into the Cellbrite physical analyzer software, I can then examine any file that's from the phone, whether or not Cellbrite was able to parse it or analyze it.
Was there something that struck you when you began the process of analyzing the bin file and comparing it with the report that the State Attorney's Office had provided?
Yes, one of the first things that I did was in the Cellbrite report that I received from the State Attorney's Office, for each section of the report it lists how many items are there, how many pictures, how many videos, how many text messages, things like that. And so I looked, when I loaded it into my Cellbrite, at the total numbers to see if they matched. And I noticed that one in particular, the picture number was off by about 600 pictures. I had 600 more than the FDLE report did.
Mm-hmm. Did that make you think there may be some additional information on the phone that was not part of the report?
Yes.
And what did you do in order to try to find those pictures?
I tried to figure out which pictures were different and whether they were all located in the same area or areas.
We're talking about comparing this FDLE report with what your preliminary indications were from your own software run with Cellbrite.
Correct.
When you got the bin file in late February, did it include an updated report from the one that had been previously provided in discovery without the bin file?
At some point, there was a second report, yes. Somewhere around late February, early March, I believe.
Was it substantially different than the first one in that it contained did it contain any of those 600 photos, for example?
No.
At some point, did you later get an FDLE report that appeared to have some of the additional data that you were later able to find?
Yes.
And when was that?
I believe it was the week before this trial started, first week of June, I think.
That was the next time that report was, that was the next updated report.
Yes.
So let's talk about what you did then in order to try to identify the data that was on the phone but not part of the report that the state provided. So were you able to extract additional information by your own application or use of the Cellbrite software?
Are we talking in general, or still talking about pictures, or?
Identify it however you choose. Once you realize there's more data on this phone than what was in the report, what did you do to try to find it?
I did a couple things. In terms of text, I started running some keyword searches, physical keyword searches against the bin files. I also, one of the things I do is I look through, the Cellbrite report did list the databases on the phone, and I started looking through the databases to see what program or app they belonged to, what they did, and what they contained. So those are the two main things that I did.
Were you able to identify some additional photos that were not part of the report?
Yes.
Did those photos include pictures of a handgun?
Yes.
Did those pictures include a hand wrapped around the grip of the handgun?
Yes.
And when you analyzed that, were you able to determine that the pictures of the hand on the handgun were taken by that phone?
Yes.
Were they?
Yes, they were.
Do you have... I'm sorry. Mr. Connor, if I could approach, please, and show
Yes, you may.
Exhibit PP. This is more than just pictures. If you would take a look at it, though, and generally describe what that exhibit consists of.
Including the text?
Yes.
There are several text message exchanges where Mr. Martin was either trying to purchase or sell a handgun. And then there are several, there's actually two copies of the two separate pictures, one of the handgun on a table or something, and then the other one where it's lifted off the table is in somebody's hand.
You were able to find those text messages on the phone?
Yes, they're on the phone.
And were some of them deleted?
Yes, they were, yes.
Is your software able to recover deleted text messages?
Well, they were marked as deleted, but they were still, the data was still on the phone. So each picture had a deleted version, although the data had not been overwritten, so it was still there. And there was another version that was still on the phone intact.
When someone who has a picture on the phone or a text message they don't want and they want to delete it, is that a purposeful action taken by the user of the phone?
Objection, that would call for speculation.
Sustained.
Is this something that happens by accident or as a result of the phone itself, or to delete the images and text messages, does that require the operator of the phone to do something?
Usually, yes.
Explain if you would.
Normally, pictures, for example, will stay on the device until they're deleted or removed. Text messages, depends on the phone, but will often stay on the device until deleted or removed. That being said, devices go bad, memory cards go bad, and it technically is possible for something to get deleted without the user intending to delete it. So that's why I said it's usually user initiated.
If you were trying to determine as an expert whether this was an action by the user or a malfunction of the phone or something, would you be able to look at the text messages that were deleted within the context of others that weren't?
Yes.
And were some of these text messages deleted and scattered within other text messages that weren't?
That is correct.
As an expert, is it your opinion that these deleted messages were because of an act of the person on the phone?
Objection. Calls for speculation.
Your Honor, may
It could be
I?
deleted by anybody. That is speculation.
Anybody, yes, perhaps, but...
But you're asking him to speculate.
No, I'm not asking him who did it yet. I'm asking him whether the text messages were deleted because of an action someone took.
Okay, well, that question would be allowed.
Yes.
Yes.
Is it your opinion that the text messages relating to the gun that show deleted were deleted by someone on purpose?
Yes.
Okay. Were you able to determine if the phone had a passcode or swipe code of some kind?
Yes.
Did it?
Yes.
What does that mean?
That means that you cannot access the data on the phone unless you input the passcode.
If you don't know the passcode, can you operate the phone?
Perhaps maybe an emergency call, but other than that, no.
Do passcodes typically time out? So that if you access the phone over a period of time, is there something in the phone that will cause it to become secure so that the passcode has to be re-entered?
Yes. For example, you may have to wait 10 minutes to try again to get in, and that time may increase each time you put in a wrong passcode.
Let's talk about what happens if you put in the right passcode and you get access to the phone. If you put the phone down and don't use it for a period of time, the phones typically have a default where they go back to the point that after several minutes or what have you, that you have to re-enter the passcode.
Yes.
Any reason to think that's not the case with this phone?
I believe there's a configuration file, and I don't recall what it said about the timeout period, but I believe it did have a default timeout period.
One would suggest, I take it, that if it didn't have some sort of timeout, that you'd only have to enter the passcode once and it would remain open forever, essentially.
Until manually locked or restarted.
Which would sort of defeat the purpose of the passcode.
That's generally correct, yes.
Is there any other information you can tell the court about that set of text messages that relate to the attempted acquisition purchase of a firearm?
Sorry, anything else that I can...
Well, are there identifiers on these text messages, who sent them, and whether or not it was sent to Trayvon Martin or by Trayvon Martin?
Yes, the messages will state which folder they are in on the phone, for example, an inbox or a sent folder, who the other party is, whether the message is incoming or outgoing, the date and time of the message, the status of the message, whether it was read or sent, for example, the content of the message, and then the status of the message, whether it was deleted or whether it's not been deleted.
Is all of that indicated on the extraction reports you have there?
Yes.
Was there a conversation between Trayvon Martin's phone and a person identified by name and number as Ron Cuevas Fulton about purchasing a .22 revolver?
Yes.
Were these conversations concerning the acquisition of a firearm clustered in date?
Yes.
When was that, please?
Yeah, just the ones with Qua Fulton, or all the ones that we have here?
All of the ones that you have regarding what seems to be the acquisition of a firearm.
Between February 18th of 2012 and February 22nd, 2012.
And how many separate collections of text messages do you have there on that?
Several. There's 1, 2, 3, 4. I think there's at least 4.
With different people?
Yes.
Can you identify who those people are from the information on the phone?
Yes.
Who are they, please?
One is Qua Fulton. That's one. There's another group that there's two other people involved in addition to Mr. Martin, but I think they run together as one kind of conversation. That's the other parties are Spoonhead Zach and Jay. And then there's another set of conversations that with another person named Ron. There's conversations with a person named Dario, and another conversations not about purchasing but about a gun with Diamond. And I think that's it.
Did you...
Fruit. I don't think I mentioned fruit.
Fruit?
A conversation with fruit also.
This collection of conversations were all between February 18th, 2012 and February 22nd, 2012?
Yes.
Were there some text messages on the phone where Trayvon Martin was talking about coming to Sanford?
Yes.
Are you generally familiar as when he was planning to come to Sanford from reviewing those text messages?
Yes.
Tell us, please.
I believe it was February 20th to 21st, around that.
And you know enough about this case that he was killed on February 26th.
Correct.
Let me show you another exhibit. This one is marked Defendant's QQ for the proffer. Let me ask you if this is based upon information retrieved from the phone.
Yes, it is.
What is it?
This is a picture that appears to be of Trayvon Martin that was resided on the cell phone, his cell phone.
Does it appear to be a self-taken picture?
Yes, it does appear to be that.
Was that picture taken with that same phone that you analyzed?
That I'm not sure. There's no metadata in the image that identifies the device the picture was taken with.
What is metadata?
Best description I've heard is it's data about data. So for example, in a picture, very often if you take a picture with pretty much any digital camera or cell phone these days, within the picture file itself will be data about the picture, the make and model of the phone or camera, maybe the focal length, the date and time, maybe GPS coordinates, all kinds of data about the picture itself. That's metadata.
Are you able from that metadata to learn more about the circumstances and the device where the picture was taken?
When it exists, yes, it often provides additional detail for us.
You said this photo appears to be Trayvon Martin. Is that based upon other photos that you know exist that depict Trayvon Martin that you've seen either on the phone or online or on TV?
Yes.
Were you also able to extract a series of text messages and other postings that appeared to relate to Mr. Martin having been in at least one fight?
Yes.
Let's talk about how you were able to recover the data on the phone that related to that extraction.
There was data on the phone in a database that was not parsed or analyzed by the Cellbrite software. And so when I went and manually looked at the database, I saw that it contained what appeared to be text messages. And then when I looked at the database and the configuration file associated with the database, the database appeared to be created by an Android app called Super Android SPC, I think. And when I researched that, I saw that it was an application that was designed in part to hide text messages. And basically what it did was text messages that were subject to this application were not put into the main text message database that you think of when you look at an Android phone. It was placed into another database that was only accessible to this Super Android application. So that for that reason, I believe it was not parsed or analyzed by Cellbrite, but when I went and looked at it, I could see the data was there, it was in plain text, and I could extract it and analyze it.
How did that get your attention? What made you think there's more here even than what running Cellbrite had revealed to you about the missing pictures and such?
There were a couple things, and I don't remember the exact order or which one was the final tipping point, but one of the things I was doing was running keyword searches, and I was getting hits of what looked like text messages, but they were not in the parsed text messages in the Cellbrite report. That was one indication. Another indication was the SPC database was listed in the databases, but there was no parsed data from it in the report. And then I know I'm missing this one other indication, but I think those were the two primary ones, the search results, and then when I eventually got to look at it, I could see that it contained what appeared to be text messages.
Is that something that you were piecing together, realizing that there was more on the phone than what was indicated in the report from FDLE that provided by the State Attorney's Office?
Yes, and I think you need to keep in mind when I originally got this data, there were certain things I had been asked to look at, so there were other things that I noticed that I was kind of noting in my mind and putting on the back burner until I got to them, and this was one of them. And
thinking that there might be something else going on, you mentioned a hidden app. Were you generally familiar with the existence of those sorts of things?
yes, I knew that those type of apps existed.
And what did you do in order to find the hidden app on this phone and then get access to the information that had been previously hidden?
Probably ought to describe what I mean by hidden. When we're using the term hidden, it's hidden from the user of the phone unless you know the app and the code. So if you wanted to see these hidden text messages, if you were holding the phone in your hand, you would have to pull up the app and it had a passcode, and you have to put in the passcode and then you could view these text messages. So they're hidden from the user of the phone unless you know how to get to them. Once I get the phone, they're not exactly hidden. They're not parsed by Cellbrite, but they're not hidden either. Once I locate the database and I access the database and view the database, I can see the data in plain text. So it's not parsed by Cellbrite, but then again, it's not hidden by the application from me either.
Are you saying that there is a passcode necessary to unlock the phone so the phone can be used, and then a second passcode that would have to be entered into this application to access these text messages?
That is correct.
So in order to get access to the text messages, arguably you'd have to know both passcodes.
Objection to leading speculation and argument.
Sustained.
May I have a little leeway with an expert to lead so we just stay on track, Your Honor? I will rephrase it though. How many passcodes would it take to get access to these hidden text messages if someone handed you the phone?
At least 2.
Would that be the access code necessary to open the phone up for any purpose?
Yes, you'd first, if the phone was locked, you'd have to put in the passcode to unlock the phone. Then you'd have to locate the app that was hiding the text messages and put in the password for that app. And then you would get access to the text messages.
How would, if you were unfamiliar with the phone, how would you know what app that was?
You would not know. You'd have to try to find and maybe see if you got lucky finding the app, and then you'd still have to enter the password.
So for someone else to use the phone, they would have to figure out the first passcode in some way.
The phone passcode, yes.
And then they would have to figure out that there was another hidden app on the phone that had text messages.
Correct.
And then figure out what the passcode was to access that application.
Yes.
And then at that point, would they be able to send and receive texts?
Yes, they would be able to see the texts that were being hidden by that application and probably respond to those text messages.
Well, I suppose if someone had gotten through those levels of security, they could, you said they could respond to the messages or delete messages or something, but...
Yes, they would basically have the access that the user who set up the application, the password, would have.
When you were looking at the context of the text messages, in the regular texting and also in these hidden files, did you consider whether it appeared that someone else was using this phone to send text messages and delete messages other than Trayvon Martin?
That's always something that we look for and keep in the back of our mind. At least I do. So yes, that is something that I took into consideration as I was examining the data.
Were the text messages that you've extracted relating to the gun and fighting, which we will talk about, contained within a larger conversation with the same person typically?
Yes.
And did those conversations appear to indicate a relationship between that person and Trayvon Martin?
Yes.
I'm losing track of my thinking here, but were you able to collect the various text messages from whatever source related to firearms and assemble them in the exhibit before you?
Yes, that is what I did.
Let's move to another exhibit. This one's been marked for identification in this proffer as NN. If I could approach the witness.
Yes, ma'am.
Are you familiar with that exhibit?
Yes.
And what is it, basically?
It's a composite of data relating to fights or fighting.
Did all of that data come from Trayvon Martin's phone?
Yes.
And did you extract it in some fashion or another?
Yes.
You mentioned earlier that there was a database that was accessible through the hidden app as opposed to through Cellbrite.
Again, there's accessing it by the user or accessing it by me. If the user's trying to access the data, they have to go through the special app and the special password. Cellbrite, from my point of view, Cellbrite does not parse or analyze the data, but it is there, and I can manually access it and view it using the Cellbrite software.
Looking at the first page of Exhibit NN, I think is the one before you.
Yes.
The header at the top has an identifier as spc.db log sorted by person.xlsx. Could you explain that, please?
Yes. I created this spreadsheet, and it comes off of the phone, and the database is the spc.db database. That's what it's named on the phone. A database, in this case it's a SQLite database, and a database consists of several tables. So for example, in this is the log table as named by the application, and it's a log of the text messages. There are several other tables. One, for example, may be the contact or name table. It'll have the names of the persons that he was texting with or in the address book, their phone number, etc. So And this is presented to me in the Cellbrite software in a table, and I can then use the Cellbrite software to export it basically into a spreadsheet, which is what I did. And my software named it by beginning with the name of the database on the phone, sbc.db, the table in the database, this is the log table, and then appending the Excel extension to the name of the file.
From a longer conversation in this thread with the person Lavandria, were you able to extract a conversation relating to a fight?
Yes, there were other messages going back and forth between Mr. Martin and Lavandria, and I extracted these specifically because they did relate to a fight.
And does your spreadsheet show the phone number of Lavandria?
Yes.
And you know this to be from Trayvon Martin's phone?
Yes.
And are you able to tell from the spreadsheet and your analysis which of the two sent and which of the two received the messages?
Yes.
Are you also able to identify the date and time that these messages were sent?
Yes.
What is the first line in your exhibit of text?
The number or the content?
I have a larger extraction here. So what's the first line of text on your exhibit?
WYD question mark, which is what you doing?
You recognize that to be text code or slang for what you doing?
Yes.
And who sent that?
Lavandria sent that.
And did Trayvon Martin respond?
Yes.
What did he say?
Tired and sore.
Did Lavandria respond to that?
Yes.
What did she say?
Me too, but what happened to you?
I'm going to ask Mr. Connor that you do the best you can to pronounce the way it's actually written.
That's what I was attempting to do.
Okay. So when Lavandria said, me too, but what happened to you, what did Trayvon Martin say?
Fight.
And what did Lavandria say after that?
Letter Y, exclamation, question mark.
And what did Trayvon Martin say to her?
'Cause man, that nigga snitched on me.
And what did she say to him?
Bay, why you always fighting? Man, you got suspended.
And what did Trayvon Martin say in response?
Nah, we thumped after school in a ducked-off spot.
And what did Lavandria say?
Oh, well, damn me.
And what did Trayvon Martin say in response to Lavandria?
I lost the first round, and it's got the kind of the happy face, I guess the colon and the parentheses, but I won the second and third.
And then did he repeat that with a different smiley face, the frown as opposed to the smile?
Yeah, it's basically the same, but it's I lost the first, but won the second and third.
And did Lavandria respond?
Yes. Oh, so it was 3 rounds with a question mark. Dammy, well, at least you won, LOL, but you need a... Actually, there's another couple words on that.
Can you read that whole line?
Yes.
I can show you my copy.
I've got a copy also.
Okay.
But you need to stop fighting, Bay, for real.
And did Trayvon Martin respond to Lavandria?
Yes.
What did he say?
Nah, I'm not done with fool. He gonna have to see me again.
Did Lavandria respond?
Yes.
And what did she say?
No, Bay, stop. You ain't gonna be satisfied till you get suspended again, huh? With a question mark.
And what did Trayvon Martin say?
Nah, but he ain't breed enough for me. Only his nose. But after that, I'm done.
The text that you read said breed.
Yes, but he ain't breed enough for me.
If that were a typo and it were an L instead, how would it?
Objection, speculation. If,
I'd have to sustain as to speculation.
Have you seen typos before in text messages that you reviewed as part of your phone analysis?
My analysis in reading this is that the word breed does not make sense and is not what was intended.
What would make sense?
Bleed,
With an L, bleed.
with an L, bleed.
Judge, I'll renew my remark, or my objection as to speculation as to that
Sustained.
remark. Ask it be stricken.
Your Honor, I would not want the record stricken. This is a proffer. This is, unless the court hasn't ruled. Did the court rule on Mr.
Ruled on
Mann?
his objection to speculation. It is what it is. What's written there is written there. What the person intended or not, he cannot testify to. What he believes may make sense may not make sense to the author of it. So that's just speculation on his part. My ruling stands.
Have you, in your training and experience and work analyzing phones, computers and phones, have you had occasion to try to make sense out of text messages or computer messages that weren't grammatically or accurate from a spelling standpoint?
Objection relevant?
Overruled as to relevance.
Yes.
In the context of this text message sequence, as you try to sort out the data on the phone and make sense of the conversation, does the word breed as opposed to bleed make sense?
I think when you put it in the context of the rest of that message, referring to not enough and only his nose, yes, I think they're talking about bleeding from the nose.
Thank you. If you would,
As to speculation.
were you able to, by analyzing the data on Mr. Martin's phone, find another conversation around that time that seemed to reference that fight?
Yes.
And to whom was that text message?
Michael Suave French.
And do you know that person from information on the phone? Did you have his contact information and other conversations between Mr. French and Mr. Martin?
Yes.
And what is the conversation that Mr. French and Mr. Martin had connected with this fight?
Mr. Martin sent a message to Mr. French stating, yeah, because he got mo hits in, yeah, because he got mo hits because in the first round he had me on the ground and I couldn't do nothing. And then Mr. French responded, dang, bro.
Is that the end of that sequence?
Yes.
Did you also find a reference to fighting by a relative of Trayvon Martin?
Yes.
Who is that person?
Demetrius Martin.
And what did where was that information located or posted?
There, it was on the phone. It was in a Facebook database. I believe the name of the database is FB for Facebook.db. Inside the database, as in the other SBC database, there are different tables. One of the tables in this database is called mailbox threads. And this particular message was in the mailbox threads table of the Facebook database on the phone.
And what did the message on this Facebook mailbox thread say?
It was from Demetrius Martin, and it said, when are you going to teach me how to fight?
Do you know from other information Demetrius Martin's relationship to Trayvon Martin?
I believe there's some kind of brother, half-brother related with the same, sharing the same father.
What makes you think that?
Because there's one other message in the Facebook database in the mailbox thread table from Demetrius to Trayvon, asking Trayvon if Dad had a Facebook page.
You believe, based upon the context of these conversations, that that Demetrius Martin was talking to Trayvon Martin about their common parent?
Yes.
Were there other references to fighting or questions? Were there other discussions in the context of your review of the text messages where people discussed fighting to some degree?
Yes.
You didn't extract those for this exhibit because you couldn't find them directly related to this event? Is it, or?
Correct, or because I could not put it in date, time, or who sent them, yes.
Your Honor, I would move the marked exhibits into evidence for the purpose of the proffer, please.
Well, we'll have to take them out of where they've been marked in the case. So NN will now come in as defendants 2 to this proffer. PP will come in as defendants 3, and QQ will come in as defendants 4 to this proffer.
In summary, Mr. Connor, sort of identifying the different places on the phone where you found information to direct the court as to what the overall scope of your work was that's reflected in some of these reports. There was some information in the report that FDLE filed initially that you were able to verify within the bin file?
Yes.
And then there was additional information in the bin file that you were later able to extract that was not contained in any FDLE report that you received prior to about June 4th.
Correct.
And there was information in this bin file that you were able to extract from applications that were hidden on the phone?
I'm going to object to leading and already asked an answer.
The jury's not here. It's fine. Go ahead.
Is that accurate?
Yes.
And to do that, to get the access to the hidden application, you had to download some software, figure out what it was all about, and review what was otherwise not visible on the Cellbrite reports?
No, no. It was not parsed or analyzed by Cellbrite. So I had to manually identify that it was on the phone and then manually go access the file or the data and look at it. The Cellbrite did not present it for me. I had to manually go find it and look at it and analyze it.
And some of that report is reflected in some of the pages of the exhibits before you.
Correct.
As well as some information that may have been extracted through the Cellbrite software itself.
Correct.
And then photographs that you were able to extract from the bin files.
Yes.
That would include the picture of Mr. Martin, the sort of profile picture.
Yes.
And the pictures of the handgun with the hand that we talked about.
Yes.
I don't remember if I asked you this. Were the pictures of the handgun with the hand taken by Mr. Martin's phone?
Yes, they were taken by the phone.
And you cross?
when did you notify defense counsel that you had found some additional information that you didn't believe anybody else had found, or at least anybody else had reported?
I'm sure it was soon after I found it.
So February-ish?
Late February, early March, yes.
And as far as the phone itself, are you aware of whose name that phone was actually in?
I believe it was, yes, I've seen the paperwork. I think it was the mother's, maybe. I don't remember whose name it was in, but I have seen it.
It was not Trayvon Martin's, correct?
His name was not on the bill, correct, or the account.
Okay. And this was actually a phone on a family account, one of several on that account. Am I right?
I believe that's correct.
Okay. And can you tell me, you referenced this discussion over a gun. You said it was between two people and either one or both of them was either trying to buy or sell a gun?
No, there were the different conversations I identified, there were 4, 5, or 6 different ones. In each of them, well, in most of them, Mr. Martin was looking to purchase a gun. In one, there was a discussion about a gun, somebody else's gun, and in the last one, somebody was trying to buy one from Mr. Martin.
Okay. And this was a .22?
There were discussions about several different calibers.
Okay. Obviously, none of which he had on his person the night he was shot and killed by George Zimmerman.
That's what I've heard.
Okay. We know what caliber that was, right?
I don't. I'm sure you guys do.
All right. As far as this, these discussions about fights or fighting, in any of them is, let me just ask it this way. In any of these discussions, can you tell me who was operating the keyboard at the time the message was sent, the keypad?
Let me answer it this way. Number one, I was not there when the messages were typed. However, when you view 8,000, 9,000 text messages on a phone, you get a flavor, you get the cadence of the people, and so you get I think I can get a pretty good idea of whether it's the same person or not.
Is that a long way of saying you would like to think so, but no, you can't tell me for sure?
Again, I was not there when the messages were typed, but do they all appear to be by the same person?
Or when the photos were taken, right?
I was not there, correct.
And in fact, as to the photo, what we've called the profile photo, it looks like you have that on the exhibit there as 3 separate dates, 11:15, 11:30, and 2:10?
No, that's the date. That's the data from the phone. It's on there 3 times.
Okay, but it's the same picture.
Yes.
All apparently originally created on 11/15 of 2011.
Probably, yes.
Okay. So we're not talking about 3 different pictures, 3 different profiles. It's the same picture, just repeated a couple times.
Correct. They have the same hash values, which means it's the same picture.
Okay. And that, of course, the profile picture has nothing to do with hands or guns or any of that being visible. It's simply basically just a torso and face shot of Trayvon Martin, right?
Correct.
Okay. And it's not posted in connection with either fights or guns, right?
Posted in terms of text messages?
Right.
Correct.
As far as this deletion, deletion can be accomplished by anybody who had access to the phone and knew the app and how it worked, right?
And the codes to get to it, yes.
So as we've discussed, you weren't there to tell me who, if anyone, actually did any of that as it relates to Trayvon Martin's phone.
I was not there when...
When were the deletions accomplished? Were they done all en masse, or were they done little by little?
I cannot tell that.
Can't tell that.
No.
So, just asking you a hypothetical as an expert.
Mm-hmm.
If a person, parent or sibling or whoever, had discovered stuff in a phone and deleted it, you couldn't tell me whether that was done like like that time all at once, or whether, for example, if we assume that the daily user of this phone was Trayvon Martin, he deleted things as he went along. Can't tell me which one of those that might have been.
I can give you my opinion.
Okay, based on, I thought you just told me you couldn't tell.
No, there's nothing in the data that tells me when a particular deleted text was deleted.
Okay.
But as you look at it, you can see that certain ones are deleted, certain ones are not deleted, and you can look for patterns. So
But as to when that got done, you can't tell me.
that is correct.
Certainly as to by whom, you can't exactly tell me, although
Well,
I understand you have a suspicion.
I
get that.
was not there when the texts were deleted.
As far as the material in the phone, any reason to suspect that George Zimmerman knew anything about any of it on February 26, 2012?
I don't know what George Zimmerman,
Certainly no communications to anybody
I
called
saw
George Zimmerman.
no text to Mr. Zimmerman.
Thank you, Judge.
Any redirect?
This idea of this mass deletion of text messages, where the text messages deleted seem to relate to certain subjects.
Certain subjects or certain people. It seems that text messages to and from certain people were deleted. Other ones were not.
Text messages about drugs and drug use that were deleted.
Yes.
Some of the text messages about the guns, trying to get a gun or sell a gun, that were deleted.
Yes.
Is there anything that would indicate to you that someone other than Trayvon Martin got a hold of this phone and deleted a bunch of these messages all at once?
No.
Were there images of pornography on the phone
Yes.
that were not deleted?
Yes.
Well beyond the scope of the offer.
Your Honor, this directly relates to Mr. Mantai's claim that someone else could have deleted these text messages. That I submit that if some family member got a hold of this phone, they wouldn't have gotten rid of the talk about fighting and guns and left all the pornography on it. I think that the court needs to know what else was on the phone that rebuts what Mr. Mantai is suggesting.
Again, it has nothing to do with the scope of the proffer, which was only as to these exhibits.
Okay, it has nothing to do with the scope of the proffer. I understand your point. Go ahead.
Could you explain that, please?
Well, yes, there are the pictures of the gun were hidden also on the phone, by a separate application that was on there. And what this application did not put them on the SIM card where pictures normally go, but it created a folder, basically in a program file, with a French language name, so it looked like it was a French language folder. And it put the pictures in that folder, and it also renamed the extension. The pictures taken with the camera are JPEG pictures, and they have a JPEG, JPG extension. What this app did was it also changed the extension of the pictures from JPEG to .bin. So in normal computer and digital data use, if, for example, you go to click on a bin file, your app's going to tell you, I don't know what this is, I can't open it. Whereas if you double click on a JPEG, it'll open up as a picture. So this app moved them and hid them, and again was password protected. And these were pictures that were not deleted off the phone. Whoever was using the phone would have to, again, have the codes to get to those items and know where they were.
Are you saying it's a separate hidden application from the one for the text messages?
Yes.
So there were two hidden applications that required a separate access?
Yes.
And the text messages were in one of them, and the pictures of the gun, among others, were in another?
Yes.
And that, if I hear what you're saying, the casual user of that phone wouldn't see those pictures unless they knew how to access that application?
Exactly.
And the application assigned a different file name so it would not appear to be a picture?
Correct. If you were just browsing the content of the phone, if say you had an app so you could browse the folders and files, you would see these as bin files and not as picture files.
Thank you.
Thank you. May Mr. Connor be excused? Can I have the exhibit?
You may.
Thank you. May Mr. Connor be excused?
Yes, Your Honor.
Thank you very
Thank you.
much, sir. You may be excused. Okay, the testimony's been proffered. I'll hear argument.
Your Honor, there's additional evidence offered. As the court is aware, Rachel Gentile has been a witness in this trial, and that she also was deposed. She was deposed over a period of 2 days, a little over a month apart, and of course the state was present. And at her deposition in April of this year, while she had denied that Mr. Martin had talked with her about fighting, that in the deposition in April, she did then acknowledge that she'd had a conversation with Trayvon Martin where he told her that he was in a fight. And in fact, he told her that he knew how to fight and that he was in a fight that he won. We know from her testimony in trial that she had only renewed her acquaintance with him after a number of years, in February 1st. So these conversations about fighting, knowing how to fight, having been in a fight that he won, took place within the couple of weeks prior to Mr. Martin traveling to Sanford. So that sort of closes the loop, if you will, on this authentication issue that I anticipate the state will argue. So we can offer the pages of the transcript, or the court can accept my proffer of the questions.
I'm sorry, I don't understand. Is it your proffer for the purposes of this proffer of Mr. Connor's testimony, or is it another proffer of something you want introduced in the trial, in front of the jury?
Your Honor, the larger issue is whether Mr. Connor will be allowed to testify as to the content of these text messages on Mr. Martin's phone. The court has already raised the question of authentication.
I just want what you just told me about the proffer of Ms. Gentile's deposition, is it for the purposes of this hearing or for the purposes of the trial?
No, for this.
Okay, thank you.
I have an excerpt of the deposition that I can just mark as an exhibit that references what I just orally proffered about that deposition.
I'm not saying I'm objecting, I'd just like to see which excerpt first. I have to make sure we're in context, please.
I'll substitute one that's not marked for the exhibit, but you're welcome to review that.
Are we ready for argument?
Judge, I'm fine with the court accepting whichever.
Okay, that'll come in for this. Purposes of this hearing is defendant's exhibit number 5. I have the other exhibits here. I have, although they haven't been remarked by Lisa, but I'll give them to her in a moment. I'm ready for argument.
All right.
If you want to mark these and then give them back to me. Thank you.
Before I forget, Judge, Mr. Zimmerman has a 10 o'clock curfew. May we have it extended until a reasonable time after
Yeah,
court?
it'll be extended for 30 minutes after court is concluded.
Is that enough? Thank you, Judge. Okay. So, on the argument part of this, we are asking that Mr. Connor be allowed to testify as to the substance of the text messages that he recovered from Trayvon Martin's phone, specifically as to the fighting. I think that's the core issue here. We laid the predicate for a picture, if it's otherwise relevant and we want to offer it, and for the pictures of the gun and the discussions about the gun. I'm not ready tonight to make the argument why the pictures of the gun and the discussions about the gun
I don't have the pictures of the gun. Defendant's Exhibit Number 4 has 3 pictures of the profile of Mr. Martin.
There is an exhibit that was marked that has the discussion of the gun.
Right,
And,
I have that, but I don't have included in Defendant's Exhibit Number 4, the first page is an extraction report with numbers 1, 2, and 3, and then it has 3 pictures of the same picture. Those are the only parts of this exhibit. I don't have a picture of a gun.
Does the court have the exhibit that has the text messages referencing the gun?
Exhibit Number 3 is an extraction report. Oh, yes, here it is. Well, let's see if the pictures are attached. There's an extraction report that has 4 thumbnails. Oh, here they are. They're attached to that, yes.
Yes, okay. And that has the gun and the handle on the gun?
Yes.
Okay. So I don't want to address that specifically tonight. The hour is late, and I'm not suggesting that Mr. Connor can, at this point, come before the jury and testify about the gun and the hand on the gun and the text messages, because I don't think that's been directly related, at least not yet, to the facts of the case. That would go more toward a notion of aggressiveness, maybe even a fact supporting a violent tendency. And
what part of the evidence code are you seeking to have this introduced? This information? All of the information that was proffered by Mr. Connor?
I believe that it most squarely is admissible under, well, no, it's different depending on what parts of the exhibit. The picture of Mr. Martin is simply that he has laid the predicate for a picture of Mr. Martin. That's not related specifically to fighting or guns. It's just a picture of Mr. Martin that was on his phone that shows his physique. That's the relevance of that. The pictures of the gun, the hand on the gun, the discussion of buying a gun and such is not directly related to the fighting issue. The fighting issue, the central core of the presentation, two legal grounds. One is 90.803. That's an exception to the hearsay, prohibition against hearsay that does not require the declarant, that the availability of the declarant is immaterial, and that it relates to an then existing mental, emotional, or physical condition. And in that primary text message with Lavandria, Mr. Martin is asked how he's doing, and he says he's tired and sore. And that's because he had just been in a fight that he had won, a fight...
What part of, I understand that, but I'm just trying to find out now, what part of the evidence code are you seeking to have that evidence admitted?
90.803?
All of them are 9803?
The text messages regarding fighting, I'm seeking under 90.803 and also under the legal authority of Chambers versus Mississippi, but that's a separate argument. I'm not addressing the admissibility yet of the firearm pictures because I don't think that we've connected that up completely with the evidence in the, before the jury. So I'd like to concentrate on the evidence of fighting and why that's admissible under several theories. Not as reputation testimony under Munoz and such, but under 90.803 as reflecting a then existing mental, emotional, or physical condition. And that mental or emotional physical condition was at the time that Mr. Martin was in the fight, that he won the fight, and that he explained how he won the fight. He won the fight by, while losing the first round because his opponent was on top of him and rendered him helpless, much like the testimony was that he rendered George Zimmerman helpless in this case.
Okay, can I interrupt you for just a minute? So it's you're seeking it under 90.803 sub 3? Okay, go ahead.
That's one of the legal grounds. That he talks about having been involved in, obviously, an orchestrated fight that was orchestrated for 3 rounds, that he lost the first round because his opponent was able essentially to take him to the ground and make him helpless by being on top. He also talks about how he won the second and third rounds and therefore actually won the fight. He also talked about how he was able to hit the person in the nose and make their nose bleed, but he wasn't satisfied that there was quite enough blood, so he talks about how he's not done yet with this guy. And of course he's cautioned by this person that he should quit doing this stuff. That conversation about that particular orchestrated fight is corroborated by the conversation with Michael French that occurs within a few hours while he talks to Mr. French about this event having gone 3 rounds. So we know those are connected in time and in content. Certainly helping toward the authentication that those were the words of Trayvon Martin to 2 people that he communicated with regularly. Mr. Connor talked about how there were conversations with these folks on other subjects and that he extracted just that part of it that related to the fights. There's also a Facebook post by Trayvon Martin's younger half-brother, Demetrius Martin, and we can offer evidence in the record to connect up all the dots on that. Mr. Martin has several children. One of them, 2 or 3 years younger than Trayvon Martin, is Demetrius Martin. He identified all of that at his deposition. So we have more of the loop being closed that Demetrius Martin asked Trayvon Martin when he was going to teach him how to fight. Obviously, Demetrius Martin thought that Trayvon Martin knew how to fight enough that he would ask for his advice and training. We also know from the evidence, the proffer of the deposition of Rachel Gentile, that within the first couple of weeks of February that Trayvon Martin told her that he had been in a fight, that he had in fact won the fight. And we know that from Rachel Gentile, who obviously knows Trayvon Martin's voice and knows him personally, and testified that it was Trayvon Martin that told her about being in a fight that he had won. All of that is strong circumstantial evidence, if not clear direct evidence, that all of these conversations were by Trayvon Martin, his words being sent to his friends about a fight that he was proud he had won because he was able to draw blood from the man's nose and to ultimately prevail, even though he'd been in a difficult situation in the first round. So factually, we've connected the dots on authenticating this. Why is it relevant before the jury? Because, as the court will instruct the jury, the relative physical abilities and capabilities of the parties is relevant. There's a jury instruction that says just that. And this jury is going to be asked to decide who George Zimmerman was physically, what his physical capabilities were, as well as Trayvon Martin's physical capabilities. And that includes knowledge. That includes experience. That includes Trayvon Martin's experience in fights, having been put in a position of vulnerability by being put on the ground. However, of course, in that fight, it was an orchestrated three-round fight. So when Trayvon Martin lost the first round, when he couldn't get up, whoever was refereeing it stopped it. And then they had two more rounds, which Trayvon Martin was able, by hitting this fellow in the face, apparently take steps toward winning. So that shows clear knowledge of Trayvon Martin prior to his contact with George Zimmerman, that he'd been in a fight, that he knew how to fight, and that he in fact knew what George Zimmerman would experience when he was on top of him, because the similar thing had happened to him in the past. We know that this is relevant because the state took great efforts to try to make that information relevant as to George Zimmerman. If the court will recall the testimony of physician's assistant Lynn Folgate, one of the things that the state took great pains to get this court to agree to, and ultimately to question Ms. Folgate on, was when Mr. Zimmerman spoke with her about his exercise regimen, that he had mentioned to her that he exercised aerobically with MMA. And the state made a big deal of that. They made a big deal about it in the case, that he had experience as MMA based upon the medical records from the Altamont family physicians, I guess it is. So we know these things are relevant because the state wants it to be relevant in their case. It's likewise relevant in our case because the jury is going to have to make that decision. So because I think that this information shows the existence of Mr. Martin's mental state shortly after this event occurred, because he's telling Lavondria that he's tired, that he's sore, that he had just been in a fight that he had won, that it is in fact admissible under 90.803.3, the existing mental, emotional, or physical condition at the time of the event. I'm not suggesting that that statement was him talking about anything in February of 2012, but it does in fact, on a relevant matter, show his thinking and his emotional and physical condition at that time. This is clearly compelling evidence in support of Mr. Zimmerman's self-defense claim. The testimony is that Mr. Martin sucker punched him, was able to soon by surprise, frankly, and then shortly thereafter was able to get him on the ground where he was mounted. We know from the testimony that mounting is when you straddle somebody around the area of the hips, and that it is an extremely vulnerable position because there are very limited acts that one can do, unless they are very skilled, to get out from under it. You are essentially helpless, and you are subject to the whims of the person on top. We know John Good said he saw Trayvon Martin mounted on George Zimmerman MMA style, and that we know from the physical evidence in the case, all of the physical evidence, frankly, especially the testimony related to firearms, corroborates that. Corroborates that the shot was fired from the ground up, that the shirt was separated from the skin by somewhere between 2 and 4 inches, and that it exactly corroborates and is consistent with not just what Mr. Zimmerman said, but with what John Good observed some 10, 15, 20 seconds earlier when he went outside to investigate. So So this is absolutely compelling evidence and is highly relevant and admissible under 90.803. We submit that it's also relevant because not to admit it in this case under these circumstances would violate Article 1, Sections 9 and 16 of the Florida Constitution and the 5th, 6th, and 14th Amendments of the United States Constitution that guarantees an accused to confront the witnesses and to present evidence in support of their defense, guarantees due process of law in presenting a defense. This theory, this constitutional principle of, if you will, preservation of the accused rights is discussed in the United States Supreme Court case of Chambers versus Mississippi. The court, I anticipate, is familiar with that decision, but what's to be taken from that decision is that a state's hearsay rules and such cannot be mechanistically applied to deny an accused the right to mount a defense. So I suggest that any application of a rule of exclusion because the court finds it to be hearsay or any other reason would be instead a mechanistic application of that rule that the Constitution of both the United States and Florida prohibits, especially under circumstances where it's clear that the evidence is reliable and trustworthy. We have closed the loop on all of this. It was Trayvon Martin's phone, it was Trayvon Martin's words in the context of all of the other words through the thousands and thousands of text messages that he had with others and with these individuals. He talked about a specific incident where he talked about his skill and the other person's skill in fighting, that he was able to injure the person, but he wasn't done with him yet. Completely consistent with what happened on February 26th when George Zimmerman was screaming for help, but Trayvon Martin wasn't done with him yet and kept on going and kept on going. We have indeed closed the loop the rest of the way with Rachel Gentel's deposition testimony, that within a couple of weeks of this event occurring, Trayvon Martin had been talking with Rachel Gentel about winning a fight, being in a fight, knowing how to fight. So this isn't something that the state can say isn't authenticated, isn't reliable, could have been somebody, anybody else just typing this stuff out. That's not at all credible. That can't possibly be the case now that you've heard the testimony of Richard Connor about these text messages, the context of these text messages, and of course what we've said here today about the highly probative value of this very, very relevant evidence. The default of this court should be to allow Mr. Zimmerman to present a defense, to guarantee his constitutional rights to present a defense. And this evidence is one step in that process. So we urge the court to allow Mr. Connor to testify about these text messages.
Thank you. Response?
But I think Mr. West has just made my point. He's got an orchestrated fight with a referee. He's telling us how many rounds there are. He's telling us that somebody's mounted another person and then they got off the ground. That's not in here. I mean, that's exactly why this type of evidence should not be before a jury. It is rank speculation. He's told a story that is not in these messages on Trayvon Martin's phone. We don't know, again, what type of fight he's talking about. If it's a slap fight, a play fight, a verbal fight, a wrestling fight, we don't know what it is. We don't know if the word fight is code for something else. We don't know anything about if there was a fight between Trayvon Martin and someone else. We don't know who his opponent was. Was he fighting Andre the Giant that he could lose a round to and then beat in a couple other rounds, or was he fighting a little girl? I mean, that's why this sort of thing should not be admitted. That doesn't even address the authenticity issue. I mean, he keeps saying we've tied all the connected all the dots. I submit to you he hasn't. We don't know who typed these messages. We don't know if they're connected. He said the message with Lavondra and to the other gentleman was hours apart. Actually, they were the next day. The message to, or the conversation with Rachel Gentile was weeks later, if not months later. Again, there's an authenticity issue, and they keep talking about the then existing mental state. We don't know when this fight was. There's no indication with any definitiveness as to when these fights took place. So,
I'm sorry to interrupt, except as a point of procedure, Mr. Manti did the cross, and now Mr. Guy is doing the argument. Are we allowed to do that here?
Well, Judge, that's the way we designed it. It's my issue. I filed the motion in limine. Mr. Connor was Mr. Manti's witness. So that's why we found that this that was his witness and my issue.
Okay, go ahead.
This was the issue I argued before the court. Judge, so again, we've got an authenticity issue. We've got whether or not it was then existing mental state. Again, there's no definitiveness as to when these events occurred. But most importantly, we don't know exactly what was meant by these words. Are they code for something else? And again, the danger is exactly what Mr. West has put before the court, that there's an orchestrated fight, that there's a referee, that there's mounting going on, none of which is in here. There's talk about being on the ground. That's it. It is not competent evidence. If there's any probative value, it's outweighed by the prejudicial effect of what a jury might imagine was meant by those text messages that may have been sent by Trayvon Martin and may have been about a fight. Your Honor, I don't know if the court wants me to address the issue of the photograph. I think it's Exhibit 4 or the information purportedly about a firearm.
The firearm, Mr. West said he wanted to address at a later time, so you don't have to address that.
Your Honor, the photograph appears to be Trayvon Martin, but they said they offered it for, I can't remember the term he used, but the best photograph of Trayvon Martin for this jury to consider is the one of him on the medical examiner's table that was taken just shortly after his death. We don't know if when this photograph was taken, we don't know if it was something that he took right after he worked out and got all pumped up and maybe took a picture of himself for that reason. We just don't know. But the best photograph are the ones already in evidence that were taken at or about the time of his death. So for that reason, I see no probative value to the photograph, as we already have that in evidence. If I can just have a moment. And Judge, they relied on Chambers versus Mississippi. Again, I don't think the purpose of that is to eradicate the evidence code and to allow into evidence items that are subject to the type of speculation and misinterpretation that this proposed evidence is. So I would ask the court to continue to grant the state's motion and deny this evidence. Thank you.
Thank you. Any further argument?
Only brief response as to the authentication issue specifically. Well, first of all, as to the content of the text messages, they are what they are. I'm not suggesting that we should be allowed to explain them when they're offered to the jury. The jury will see them and give them whatever weight they choose to give them based upon what they believe them to mean. As to the authentication issue, this issue is mired in the mess that discovery on this issue has become. There is a pending motion for sanctions before this court that will be taken up at the end of the trial because Mr. Della Rianda stood before this court and said, we gave the defense everything. We offered the testimony of Wesley White, we offered the testimony of Ben Credos, that in fact wasn't true. And we finally got the report from Mr. Brenton at FDLE on June 4th. June 4th, and we still haven't had a chance to go through it because we had the Fry hearing, we've had 2 weeks of jury selection, and what is this, our third week of trial? I can't even keep track of time. There is an ongoing discovery issue, violations. In fact, Mr. Guy stood there silently when Bernie De La Rionda said, we gave him everything. There's no other report. We didn't get any information from anybody different than what we gave them. And we know that's just not true. Mr. O'Mara said to this court, let's relax some of the authentication issues, if nothing else, because we can't get through this issue with the timetable the court has set. There is no authentication issue. In fact, the authentication issue that Mr. Guy raises is illusory. And to the extent this court thinks there is one, it's because of the state's misconduct, not because of anything that we've done.
Even if you were to take everything out of that bin file, it would still be the same issue. It's coming from the same phone.
We did not have the ability.
Well,
we were misled, Judge. We were given a.
Go ahead.
We were given a report at the same time we were given the bin file in late February. The report was misleading. It did not contain the same information that the state had in its possession at that time. We got the report, which was incomplete.
Mr. Conner testified that he found 600 additional photos that the state didn't know about. So
that's not true. That's just not true.
I thought I heard him say that. I'm
well,
sorry.
That's what he said, but that's not true that the state didn't know about them. We had testimony before this court from Ben Kritos that he
We're
printed
getting off
2
on
reports.
a really side issue, because my point being is, if you had 5 years to look at that bin file, it's still coming from this same phone.
We
correct?
only wanted an
it's
extra week.
It's still coming from this same phone, correct? Yes.
The data set is the data set, yes.
Okay. It's still coming from this phone. The information that you're seeking now to introduce through Mr. Conner, I do have an authentication issue about it. 90.901 is the requirement for authentication or identification. 90.901A, 901.1A, and I'm reading from Earhart. The most common method to authenticate the electronic record or message is by the testimony of a person with knowledge who created the record or message of that printout accurately reflects the contents that the witness created or sent. And it goes on and it brings you to footnote number 3, and it references Griffin versus State, 419 Maryland, 343 19A 3rd 415 2011, and State versus Ellick, ELECK, 130 Connecticut Appeals, 632 23A 3rd 818 2011 case. An electronic document, example, email, text messaging, and networking sites like Facebook, may continue to be authenticated by traditional means such as the direct testimony of the purported author or circumstantial evidence of distinctive characteristics in the document that identify the author. Typically, electronic messages do have self-identifying features. For example, email messages are marked with the sender's email address, text messages are marked with the sender's cell phone number, and Facebook messages are marked with a username and profile picture. Nonetheless, given that such messages could be generated by a third party under the guise of the named sender, opinions from other jurisdictions have not equated evidence of these account usernames or numbers with self-authentication. They cite another case of Commonwealth versus Purdy, 459 Massachusetts, 442, 945 Northeast 2nd at 372, 2011 case. Evidence that electronic communication originates from email or social networking website that bears purported author's name is not sufficient alone to authenticate it. Another case, they cite emails authenticated not only by defendant's email address but also by inclusion of factual details known to the defendant that were corroborated by telephone conversations. And my point being is that what has been presented to the court, Exhibit 2, Exhibit 4 is the profile picture, Exhibit 2 and Exhibit 3 has nothing identifying Mr. Martin. He doesn't say, hey, this is Trayvon, or it has going out to Lavandria, coming back in from Lavandria. It has the phone numbers, it has the time, but anybody could have picked up that phone and sent these text messages. A third party could have access to it. People have children who pick up their phones and play with them and send text messages to their friends or other people. I don't have any identifying marks that these text messages are created by or sent by Mr. Martin. I have a concern about that.
Well, we know the phone had a double level of security. We know that.
And I know any 7-year-old can learn the passwords and get into that because they do it all the time.
FDLE couldn't do it for a year almost.
Well.
They sent this phone all over the country, and they had to write code for it.
But a person may know that password. Another person may know that password. FDLE didn't know the password.
Right, it's evident under 90.901 that there's evidence sufficient to support a finding that it is what we claim it to be. All of this came off of Trayvon Martin's phone. There are thousands of pictures, thousands of text messages, no indication that anybody else was using his phone. Mr. Connor looked at all of those text messages. Further, under the authority of is it Manuel?
Yeah, it's on the same page.
Manuel v. State, is that the one you're talking about? 357 Southwest 3rd, that one?
Yes.
Cited in Earhart's book, I guess, Mr. O'Mara pointed this out to me, to suggest, I don't know what else we could do under these circumstances when the state didn't give us the information timely.
But even if the state gave you that information, is my point, what on these text messages identify that they were created by Mr. Martin?
We would have had the time and the opportunity to find the witnesses on the other end, first of all. And we have not had that because of the state withholding valuable, exculpatory, probative evidence in this case repeatedly, and then misrepresenting to the court what they did. And then finally, when we caught them doing it, we get it on June 4th. Judge, I don't know what else we could have done, frankly. We asked for time. We wanted to depose Steve Brenton. We asked the court to delay the case a few days. I don't know what else we could have conceivably have done under the circumstances to further this authentication issue under the circumstances that the state is solely responsible for. It's simply unfair for Mr. Zimmerman not to be able to put on his defense because of the state's tactics. It was a strategy, obviously, because they had it in January and kept it from us, made us spend 10, 20, 30, 100 hours digging it out, playing games with us, lying to this court, and now it's our fault? It's our fault? To deny Mr. Zimmerman the right to present this information violates both the Florida and the United States Constitution. Thank you.
Does the state want to respond?
Judge, not in substance, but because Mr. West said, I would offer him the opportunity right now to apologize to me for suggesting that I stood by silently with information that I did not have.
I'll respond to that, Judge.
I'm not getting into this. Court is in recess. I will give my ruling in the morning. I'll see you at 8 o'clock in the morning.
May
Court is in recess. It is
It's 10 o'clock at night.
9:56. No, court is in recess. Thank you very much. With all due respect, we'll see you at 8 in the morning. Well, at 8 in the morning, the issue is Mr. Donnelly, who may have violated, or counsel has informed the court that you know that he violated the rule of sequestration. That's the second time today that I've heard that there's been a violation of the rule of sequestration by the witnesses. I don't want to take that up at 9 o'clock and have the jury sit out there and wait like they did today. We will be in recess until 8 in the morning. And so have I.
Not being able to prepare or get my witnesses gathered for tomorrow, and I can't do it tonight.
I'll see you at 8
Judge,
in the
I'm not
morning.
physically able to keep up this pace much longer. It's 10 o'clock at night. We started this morning. We've had full days every day. Weekends, depositions at night?